Remember that after the proclamation of Diosdado Macapagal as president, and before Garcia stepped down as president, he issued about 350 appointments, and he intended to have them all installed days or hours before the swearing in of the new president. So that went to the Supreme Court, and the Supreme Court said, this is a midnight appointment which we cannot allow. When the new president is already known and proclaimed, the incumbent president just has the authority to ensure an orderly transition of power. So the appointments made by President Garcia were all invalidated. This was the inspiration for Article 7, Section 15 of the Constitution, which says that 2 months before the next presidential election and until the end of the term of the incumbent president, the president may not make any appointments except temporary appointments to the executive department in cases where this is absolutely necessary. And this provision was first tested in 1998 in the case of Valenzuela, in the case of Villarta, where what was involved is the appointment of two judges of lower courts. And the Supreme Court said that the prohibition applies to judges of the Supreme Court, of lower courts, and only temporary appointments to the executive department is allowed. Now, we have two provisions in the Constitution which are in apparent contradiction. We have Article 7, Section 15, which says that 2 months before the next presidential elections and until the end of the incumbent president's term, he may not appoint anybody except to the executive department in temporary capacity. And then you have Article 8, Section 4, which says that any vacancy in the Supreme Court must be filled or shall be filled within 90 days from the occurrence of the vacancy. There's a slight difference in the provision for the Supreme Court and the provision for the lower courts. So the provision for the lower courts, 90 days from the submission of the list to the Judicial and Bar Council. If you take a look at these provisions in concrete, they are in apparent contradiction. So that the principle in law is that when their two laws are in apparent contradiction with each other, effort should be made to make both of them effective, if that is at all possible. So if you take a look at the prohibition in Article 7, the prohibition takes effect from March 10, 2 months before the May 10 election, and extends until June 30, at the end of the term. Now, if you look at if you apply the second provision, commanding the appointment of a justice of the Supreme Court within 90 days from the occurrence of a vacancy, you would have from May 17 until August 17. In other words, whoever the next president is will have something like 45 days still to make the appointment. So in my view, this is what should be followed. Both laws should be allowed to take effect. Now, there are some other legal things involved here. What are the requirements for the validity of any appointment? First, the appointing authority must have authority. Second, there must be a vacancy.